Okay, my YouTubers, I hope that you are enjoying the podcast so far at My Life as a Landlord. I am super excited to bring you today's topic. And even though sometimes I don't always get a guest, that doesn't mean that I don't get great information. And that's exactly what happened today. I'm hoping that you learned something. Here we go. Well, hello there. Welcome to My Life as a Landlord. I am Dr. Jen, and I am so happy to have you today on episode 51. This is a tenant perspective topic, and I am super happy to share with you the detailed response that I received from the Office of the Privacy Commissioner of Canada. I emailed them and said, hey, want to be a guest on my podcast? And while they declined the interview, they provided an amazing email with a ton of information. And I'm going to go through that email, and then we're going to put the email with the live hyperlinks up on the website, mylifeasalandlord.com. But I'm excited because this whole idea of privacy is becoming more and more critical. And as a tenant and also as a landlord, you need to know, whether you're in Canada or the US or beyond, that privacy is becoming more and more of a hot topic. And so here we go. Even though I don't have a guest on today's podcast, the expertise that comes through this email, I can't wait for you to understand it. And I have reached out to so many different guests, and I've gone big. I'm not going to read the potential guest list, but just know they're big, and it's all about providing value to you. So the Office of the Privacy Commissioner of Canada responded, and I'm going to go through this email. I'm not going to read it word for word. I'm going to go through it because they do provide some similar items, but this is pretty neat. So the person who reached back out to me is named Vito Pilieci, Pilieci. And this is, of course, their tag on the bottom is in English and in French, because this is the Office of the Privacy Commissioner of Canada. They've got to have the English version of the email is, of course, what he sent me. I'm assuming it's a he, but pretty interesting information. So I'm just going to keep going. I'm just going to read through this, and then I'll explain as we go. So hopefully this isn't too boring. But again, take a look at this. Thank you for reaching out to our office. Please find below the information about the federal private sector privacy law and how it applies to the context of landlord and tenant relationships. Unfortunately, we're not able to provide an interview at this time. Okay. So just a few opening sentences. Federal private sector privacy law. So federal means it is countrywide. And by the way, US is similar. And I'm finding that when you're comparing between the US and Canada, it seems that Canada is actually more strict than the US. So I'm just going to put that out there. It seems that way, but this for the context for my US listeners, this seems to be pretty interesting as far as privacy, the leading edge of the privacy requirements. So this is federal. This is not state, territory, or provincial. We'll talk more about that as we go. And then private sector. These are not public companies. This is not an organization. He's talking about private sector folks like you and me. We're talking about for-profit, typically companies or mom and pops. That is exactly who we are. Or we've got tenants. Tenants are individual people, and this is all part of the private sector. Okay, here we go. Landlords in Canada may be subject to a few different laws regarding privacy. The Office of the Privacy Commissioner of Canada is responsible for overseeing compliance with two things: Personal Information Protection and Electronic Documents Act, or PIPEDA, Personal Information Protection and Electronic Documents Act, and the Privacy Act. So you've got PIPEDA and you've got the Privacy Act. Okay, PIPEDA, again, I'll say it again. Personal Information Protection and Electronic Documents Act is Canada's federal private sector privacy law, which applies to the collection, use, and disclosure of personal information in the course of commercial activities, such as rentals. The Privacy Act, the second part of what the Office of the Privacy Commissioner of Canada takes care of, the Privacy Act is Canada's federal public sector privacy law that only applies to federal government institutions. So here we're only talking about PIPEDA, okay? Personal Information Protection Electronic Document Act. Okay. Further, 3 provinces, British Columbia, Alberta, and Quebec, have private sector privacy laws that have been deemed substantially similar to PIPEDA on the provincial side, which may apply to commercial organizations such as Landlord instead of or in addition to PIPEDA in those provinces. So he's mentioning specifically that depending on where you are in Canada, it may not just be the federal stuff, it may also be provincial stuff that requires for privacy laws. Okay. So then we talk a little bit more. He talks about what the privacy commissioner is, how it all works, and then he goes into a couple of different how the commissioner is ruling on privacy stuff. This is really interesting because you guys you're gonna see this, especially if you're any of the forums on social media. Okay, so let's talk about the privacy commissioner of Canada. This person is actually an agent of Parliament, of Canada Parliament, whose mission is to protect and promote privacy rights. The office of the privacy commissioner of Canada is headquartered in Gatineau, Quebec, which I didn't know. That's kind of cool. So back east. And they've got several hyperlinks. So they said this page contains the contact information, including the information center, which responds to questions from individuals, organizations about privacy rights and obligations. So if you are a tenant listening to this, you can go into one of these hyperlinks directly to the Office of the Privacy Commissioner of Canada and write to them directly, just like I did. I did the same thing. And you can go in and say, this is what's happened. This is what's going on. What are my rights as a tenant? Similarly, you can do it as a landlord. Okay. Now they've got so many people asking questions that he continues. We have developed the following guidance, which discusses privacy issues affecting tenants and landlords, such as tenant concerns about overcollection and inappropriate use of personal information, the use of surveillance cameras, and the disclosure of tenant information to third parties. Interesting. So there's a hyperlink there that says privacy in the landlord-tenant relationship. Now you can already see what my call to action is going to be, is I want you to go in and take a look at all these hyperlinks. But I'm going to keep going because there is so much information in this email. It's as if I'm interviewing him because this was such an amazingly well-written email. I was so excited to share this with you. Okay, let's keep going. Where was I? Our office regularly receives questions from both landlords and tenants pertaining to various issues, including including what personal information is acceptable to collect, how that information can be used once it is collected, and how should the information be retained after it is collected. Both landlords and tenants should know where PIPEDA applies. Again, PIPEDA is Personal Information Privacy and Electronic Document Act, where it applies, and it sets out a number of obligations for organizations. Again, there's hyperlinks all through this so that if you've got a question, you just go in. Generally speaking, PIPEDA requires organizations to obtain meaningful consent specifically from the tenant for the collection, use, or disclosure of personal information, such as, for example, the purposes of tenant screening or tenancy management. In this regard, our office has issued guidelines for obtaining meaningful consent. So I'm going to stop right here. For my Canadian landlords out there, and also for the US landlords, I mean, this is not a bad thing. The privacy guidelines is here. You've got to receive meaningful consent from your tenants, your potential tenants, to collect information from them. So the guidelines here is pretty spectacular. It's very specific on what you need to do. Check boxes on your applications, the verbiage that you need to use. You need to go in there and learn a little bit more about this. Furthermore, he continues, the collection of personal information must be limited to that which is needed. Personal information must be as accurate, complete, and up to date as possible. And individuals have a right to see the personal information that businesses have about them on file and to correct any inaccuracies upon request. Landlords should be prepared to respond to such accuracy. Landlords should be one more time. Landlords should be prepared to respond to access queries from tenants. Organizations are also required to safeguard the personal information in their care. And the safeguard aspect in that sentence is hyperlinked. How do you safeguard stuff? You safeguard it with locked cabinets, passwords on computers, things like that. And they talk exactly about how to do it. Now, let me just step aside here for a second when we're talking about this. Landlords should be prepared to respond to access queries from tenants about what personal information the business has on file. In the event a tenant has provided a credit report and score, or they've provided consent for me to pull their credit or paid for their credit, regardless. Remember, on the Canadian side, a landlord pays for the credit report. On the US side, the tenant pays for the credit report or provides it, either way. But if there is something in that credit report that I have found as a landlord, I always go back to the tenant and I say, are you aware this is in here? About half the time, the tenant is aware, and the other half the time, they had no idea there was something in here. And so it works both ways. You may not just have a tenant asking for what information the landlord has on file. It may also be the landlord finding stuff saying, hey, look, did you know that this was in your credit or this was going on? Okay. Here we go. Now we go into two different scenarios about complaints that have been filed in their office. And this is really interesting because I have seen both scenarios in the discussion forums and social media. So this is very interesting how we go. Okay. If an individual believes that an organization is not respecting its obligations under PIPEDA, again, PIPEDA, privacy, wait a minute, let me go back up here. Personal Information Protection and Electronic Documents Act. Okay, that's PIPEDA. They have the right to file a complaint with our office. This is typically tenants filing a complaint with our office. And the file a complaint, of course, is a hyperlink. Our office has investigated some complaints related to issues pertaining to landlords and tenants. And for example, there are two scenarios here, and I'm so excited to share these scenarios with you because they are absolutely white hot and active on social media right now. Okay, so there's two ones. And of course, they both have hyperlinks to the full report, okay? A complainant alleged, okay, wait a minute. Let me go back and read the heading. Okay, property management company created a quote unquote bad tenant list. And as a result of a complaint filed with the office, they agree to scrap that bad tenant list. Okay, so here's how this went down. A complainant alleged that a property management company was improperly collecting, using, and disclosing tenants' personal information in order to create a list of quote unquote bad tenants. The information on the list was being shared with a database operator who made the list available to other landlords online. Our office recognized that the collection, use, and disclosure of the personal information by a landlord may be appropriate in certain circumstances, but this would be for the express purposes of verifying a prospective tenant's ability to pay rent on time or to determine suitability in the context of a rental application process. However, in this case, the Office of the Privacy, let's see, I want to make sure I say it right. Office of the Privacy Commissioner of Canada, the office found that the database operator failed to take the adequate steps to ensure landlords had obtained meaningful consent from the tenants to include their information in such a list. Furthermore, a bad tenant list included information about the individual's past paying habits, and we found that by providing members of a landlord association to this type of information, the property management company was, in the context of the applicable provincial legislation, acting as the credit reporting agency and was doing so without the required license. In those circumstances, it was our view that the purpose for which it was collecting, using, or disclosing personal tenants' information was not appropriate and thus a violation of PIPEDA, Personal Information Protection and Electronic Documents Act. Very interesting. We've talked about this quite a bit on social media, saying, you know, can these are the bad tenants. Can we create a bad tenant list? Well, the answer is no, not for the purpose of sharing about the bad tenants, because there's no meaningful consent. Okay, so that's very interesting. So the second one is all about using surveillance cameras. When using video surveillance, security needs must respect privacy requirements. This is interesting. Okay. So the Office of the Privacy Commissioner of Canada received a complaint, and this is how Veto responds. This investigation involved an individual that complained to our office about the use of video surveillance in his rental building. He alleged that the video cameras installed in the building were collecting excessive and unreasonable amounts of personal information. As a result of this investigation and in response to our recommendations, the property manager to the property agreed to remove the hallway cameras in the building stairwells and reposition all outside cameras so they did not record the public spaces to ensure the video is viewed after security. And wait a minute, let me slow down. And to ensure that the video is reviewed only after security related issue has been reported. Fantastic. So I have security cameras on my properties and they are all recording public spaces. And here's the funny thing. We don't look at them unless there is a problem. And honestly, most of the problems that we have are bears encroaching on the property. This is in Canada. It's not necessarily a security issue for anything else. So this is very interesting that the Privacy Commissioner has ruled on this. Okay. I also discussed how about what does a tenant do if there has been a breach in privacy? What is actually the whole protocol on how to do? And so he asks specifically, or he answers specifically about my question about the breaches. Okay. He says, finally, you asked about breaches in security. Organizations subject to PIPEDA are required to report. And of course, that's a hyperlink. Required to report to our office and notify the affected individuals of all breaches involving personal information that create a real risk of significant harm to an individual. Real risk of significant harm. Now, that's a pretty technical word. And again, that's also a hyperlink. I'm not going to go into what that is, but real risk of significant harm to an individual is the requirement. You've got to report it. This requirement applies to landlords who are subject to the Act. And of course, I'm talking about the Personal Information Protection and Electronic Document Act. Once an organization has determined that a breach of security safeguards involve a real risk of significant harm to an individual has occurred, it must, there's 4 things it must do. Contact the affected individuals as soon as feasible. That makes sense. Directly notify these individuals by email, phone, or any other appropriate form of communication. In certain cases, individuals must be indirectly notified if you can't get a hold of them. For an example, if an organization does not have a person's contact information, then in this case, indirect notification should be made via a prominent public announcement, which could maybe be a poster or something outside of, let's say, an apartment building. If you had a privacy breach and you no longer have contact information for someone that maybe doesn't live there anymore, right? Because otherwise you'd have their contact information in theory. Okay, in the last aspect, they said give the individual where the privacy breach has occurred, give the individual an easy to understand information to explain the situation, which is what happened and when, what is being done to remedy the matter, the steps the affected individual could take to protect themselves from harm. For example, change your passwords, change your login for your computer, that kind of thing. And a person that the individual can contact should they have any questions. And of course, they have 2 bigger hyperlinks saying for more information on privacy breaches, there's 2 links here. It says what you need to know about mandatory reporting of breaches of security safeguards. And then the second one, tips for containing and reducing the risks of a privacy breach, which is pretty interesting. So because today's podcast is tenant based, I also put this, and he ends his email saying this: we have also developed information for individuals, which is a hyperlink, explaining what they should do if they know they have been affected by a breach and received a breach notification for an organization. So if a tenant information has been compromised and presents a real risk of significant harm, then the Office of the Privacy Commissioner Canada has gone back and said, okay, here's information of what this tenant could do based on this breach. And so it's very interesting how this all is. I'm going to put this email on the website, and I've instructed my team to make sure that we can do it with all the live hyperlinks, because this is really chock full of information. I mean, you could go down any one of these hyperlinks and learn more about privacy requirements. And it's becoming a bigger issue. I suspect we're going to do more podcasts on privacy. And probably next time what I'll do is I'll do it from the US side. So you can see it from the US side as well. I suspect you're going to see it's a lot of the same thing. So here's your call to action, my friends, my listeners, all of you out there trying to educate yourself. Go to mylifeasalandlord.com. Check out this incredible email that I got from the Office of the Privacy Commissioner of Canada. Make sure you're in compliance with the privacy requirements in your area and that you're educated on their privacy requirements for tenants, right? Tenants out there, you need to understand what your landlord should be doing properly through the entire entire aspect of your housing journey. Educate yourself, which is great. So go and check this out. I was just thrilled and floored when I saw this email response for the Privacy Commissioner of Canada. That was phenomenal. Thank you so much for joining me today. Let me know your comments and questions by email me at learn@mylifeasalandlord.com. Don't forget the free resources on the website, including this email and 2 free blackout bingo cards. I'm excited for you to educate yourself and track it in a fun way while you're doing so. Join me for next week's podcast topic. It is an other Salisbury adventure. Episode number 52, I interview my U.S. Naval Academy classmate, who happens to be the Deputy Commandant at the U.S. Naval Academy right now, guest Navy Captain David Foreman. I will see you there.